great importance nowadays, as you have seen that real estate is a very promising sector and it is thriving. It has we have seen various developments in real estate sector, specifically after enactment of RERA. As we all are aware of Real Estate Regulation and Development Act 2016. The position, so I can start with here only. We can talk about the implementation of RERA and what was the purpose behind enactment of RERA. Earlier there was a problem. The real estate market, it wasn't that much regularized, and there was lack of legal remedies. Earlier people only have consumer court remedy in case of non-possession. If the builder has delayed in giving possession to buyers, then earlier before 2016, when RERA Act was not enforced, so at that time allottees only had an option to approach consumer courts. But now, after enactment of RERA, there is a better transparency in real estate market, I would say, and there is a speedy disposal of cases. And so now they have, in fact, not two, but they have three legal forums. Consumers, they have three legal forums. Now they have RERA court, now we have consumer courts, and we have NCLT also. NCLT jurisdiction is also there, but in that case there is a capping of there should be a certain prescribed number of allottees. Only they can approach to NCLT, they can take the matter with NCLT. That is the thing. Now if we talk about the challenges, let us first talk about the challenges under RERA Act. The ultimate objective of RERA Act was to bring transparency in the real estate market. And just like we have many other regulators, for us to regulate capital markets, we have SEBI as a regulator. We have many other regulators to regulate different markets. So RERA is also a kind of watchdog. RERA is a regulator to regularize real estate market. Now, see, the problem is RERA is a central act, but we have different states. The first and foremost challenge which I see personally is that there is not proper implementation of RERA Act. Still there is state, I would call it state level variation. Many states still not have RERA authorities. They still not have appellate authorities. This is the biggest challenge which we are facing. There are so many states. As per the data of 2023, only 32 states have RERA authorities out of 36, and 28 states have real estate appellate authorities out of 36. Still many states are lagging behind. This is the challenge. And then the other challenge is that still people lack that awareness. They are confused. They are getting confused between different jurisdictions. Earlier, what was the scenario? There was only one jurisdiction, the jurisdiction of consumer courts. But now we have RERA courts, we have consumer courts, and we have NCLT jurisdiction as well. There is still a lot of confusion among people with respect to jurisdictions. That is the problem. That is, I would see it as a challenge. And the third thing is that there is so much of despite the presence of RERA authorities, despite the enactment of RERA Act, still there is, unfortunately, delay in possession of property by the builders, which is very unfortunate. In fact, in one of the case, buyer had delayed possession, developer had delayed possession for 11 years, which is too much. I would like to quote a judgment here. In one of the judgments, considering this scenario, in one of the important landmark judgments, Supreme Court has recently held that right to housing is a fundamental right under Article 21 of the Constitution. The name of the case is Mansi Brar Fernandez versus Shubha Sharma and another. Considering the current scenario, because buying a home and constructing a home or property, it is like a dream of every person, and Supreme Court has declared this thing as a fundamental right under Article 21 of the Constitution of India. Builders are still not understanding the importance of RERA Act, and there are still many bottlenecks. There are so many bottlenecks, so that a project is getting hampered. There is no timely construction of the projects. That's why it is, there is so much of delay in delivery of possession to the home buyers. That is the kind of problem. There is one more judgment which I would like to quote here. Apartment Owners Apex Association versus State of Kerala. This judgment is being pronounced by Kerala High Court. In this judgment, it was held that promoters shall not accept deposits or advance payment without first entering into builder-buyer agreement. This I see as another challenge. I have seen in Haryana also specifically, I have seen that many builders, they accept advance deposit from the prospective buyers without even proper advertisement, without even proper launch of the project, which is wrong and which is a kind of contravention of the provisions of RERA Act. And this has been rightly held in this case, Apartment Owners Association case, that promoters can't do that. You cannot accept deposit before proper launch of your project or before proper advertisement of your project. Now, if we talk about some other challenges, one of them is compliance of orders under RERA Act. Whenever the order is being passed by the RERA code, be it a refund order, be it a DPC, delayed possession charges, buyers or allottees, they are facing a lot of problems. There is still non-compliance of orders. Execution, there is no better provision of execution under RERA Act. I think government should definitely think about this thing, that RERA, they should empower RERA authorities so that they can deal with execution cases in a time-bound manner. There are no stringent provisions with respect to execution. Order pass हो गया है कोर्ट से, but buyers जो है, जिनके फेवर में orders pass हुए हैं, वो उसको execute ही नहीं करा पा रहे. That is the problem.
Got it.
So if we talk about, so these are a few challenges with respect to RERA Act. There is not parity. There is still not parity with respect to implementation. Other thing is that, as I have seen personally also, that there is understaffing in most of the courts, RERA courts. Other thing is that there is understaffing. We need more staff. There is a lot of pendency in RERA courts. We need more staff, smart people to deal with the court cases, to manage the court cases. Other thing is there is lack of, I would say, digital infrastructure in our country, because everything is online now. Builders have to register their projects online. You can file complaint online. But there is no, you can track your case status online. You can track your order online. Court order is there. Everything is online. But my question is, how many states have better or robust infrastructure? Many states, I'm not talking about Delhi and Haryana. I'm not talking about, they have a better infrastructure. But still many states, they do not have a better digital infrastructure. How the projects will get registered, how the builders will get their project registered, how you will keep track of your cases, how you will file online complaints. These are multiple bottlenecks with respect to implementation of RERA. I'm not denying this fact. It has brought a lot of transparency. There is better adjudication of cases now, and people are getting refunds. If your project is not being delivered to you on time, people are getting refunds of the projects. They are getting delayed possession charges. But still, there is no proper implementation of RERA Act, which was supposed to happen. Now, if we talk about development, these are a few challenges which we have just discussed. Now, if we move forward towards developments, latest developments, if we talk about, is that now earlier, at the time of enactment of RERA, at that time, and after that, it is a 2016 Act, and till 2017, it was taking a lot of time in getting projected and getting that sort of implementation across various states. Now, many states have RERA authorities. They still have RERA authorities, but in Sikkim we have interim authority. There is no particular RERA authority. That is the problem. But the point is, there is variation. As we discussed during the, when we were discussing challenges, still there is no parity. Some states have different provisions. Some states have in some states the authorities are acting differently. In some states the authorities are acting differently. That is the problem. Considering this scenario, recently Maharashtra government has proposed that there should be an independent authority to oversee the development of projects and redevelopment of projects. Let's see whether this proposal will be implemented or not, but it is a very, very good proposal. And so in the case of Haryana also, the government has proposed that there should be, the RERA proceedings, they should be held in fast track mode for a speedy disposal of cases and better implementation. Disposal is better as compared to conventional courts. If you go to consumer court, if you go to NCLT, disposal is better in RERA. But there are certain issues with respect to disposal. It is still taking time. That's why Haryana government, they have proposed that there should be that it should be held in fast track mode. However, this proposal, it is still a proposal, it is in pipeline, it has not been implemented yet. And earlier what used to happen, there was no specific definition of carpet area. But after enactment of RERA, I definitely see it as one of the development, that now after enactment of RERA Act, we have a specific definition of carpet area, which has been defined under section 2K. You may note down the section. It has been defined under section 2K of the RERA Act. Now you have to charge, so builders, they have to charge on the basis of this specific area only. They cannot manipulate the calculations. You getting me? Now they cannot manipulate the calculations. And in one more development I would like to cite here, in one of the case, Punjab and Haryana High Court, they have held that penalties from RERA must be faced. If in case of non-compliance, builder, they have to face certain penalties. So penalties they have to face even if the concerned developer company or builder company, they are facing insolvency proceedings, which is, I see it as a very, very good development, because now you cannot be absolved from your liability that I am undergoing the insolvency proceedings, I do not have money. Now builders cannot make such kind of excuses. The court has held that even if you are undergoing insolvency proceedings and you do not have proper funds, it doesn't mean that you will not refund to the buyers, or you will not give delayed possession charges to the buyers. You have to, if it is mentioned specifically under builder buyer agreement that you have to give possession from so and so date. For example, usually what happens, I have seen that in builder buyer agreement, usually it is the delivery date is 4 years from the date of commencement, 5 years from the date of commencement of the construction. Let's say the agreement has been executed in 2017, or let's say it has been executed in 2018. Then as per that BBA, builder buyer agreement, a builder has to give possession within 4 or 5 years. So if it has been executed in 2018, they have to give possession by 2022. But this thing is not happening. So there is a clear-cut violation of this provision also. Despite making it a clause in builder buyer agreement, many builders are still taking so much of time in delivery of project or in handing over the possession. And recently, Haryana RERA, they have ordered refund of 41.6 lakhs for a flat booked in 2014, and the possession was promised in 2017. The project was delayed for 11 years. And there was COVID in the middle, there was COVID also, there was COVID situation, there was demonetization also. Despite that, court did not listen to the builder, and they have penalized the builder with such hefty amount of 41.6 lakhs. Now the point is, there is better transparency, the provisions are stringent, you just cannot nearly escape. You cannot be fooled, or you can not, the builders, they should not get duped by seeing all those advertisements, those flashy advertisements. The problem is, whenever we see those kind of flashy advertisements and on the TV or on the roads, you see those signages of so and so builder that we are coming up with this project, that project, or everything. All these things are so it is very attractive. It is very eye-catching. You feel like investing in so and so project. As far as this advertisement part is concerned, recently Tamil Nadu government, they have proposed that there should be new rules of advertisement. What they have suggested as a part of new rules, that now whenever you are advertising your project, you have to specify your registration number also. You have to specify your RERA registration number, QR codes, approved location, and every other important detail with respect to the project. It should not be, they have also proposed that it should not be a vague advertisement. Advertisement ko dekh ke hi people are investing in your investing in your project. That's how these developments we have seen, which have happened recently. Many governments, they have come forward. Governments of different states, they have come forward and they have given their proposals for better implementation of RERA Act. And now in this session, I would also like to discuss certain penalties, only for the information of the audience, that if without registration you are launching your project, there is a provision for heavy penalty which may extend up to 10% of the estimated cost of the project. I'm just discussing the penal provisions. And there is one more provision of QPR. quarterly project report, which every builder has to file on quarterly basis, so that the RERA authorities will get the idea about the progress of the project. That is a very, very important compliance. It is one of the most important compliance under RERA Act, and there is the provision of very high penalties. There is a specific due date. If you do not file your QPR within a due date, then 10,000, then you shall be penalized. And if there is submission after 30 days, then it is 25,000 and so on. Then it keeps on increasing the penalty. And other thing is that अगर आप manipulate कर रहे हैं अपनी QPR को, if your QPR is defective, then the penalty may extend up to 5% of the estimated cost of the project. Now you can take an idea how hefty penalty has been imposed on builders with respect to this. And if your other thing is that if your registration has got expired and it is supposed to be extended, let's say your registration is for a certain period and it has you have failed to get it renewed, now it has got expired, then the penalty will be 10% of the estimated cost of the project. That's how there are very stringent provisions. Now if I talk about Gurgaon, and if you just fail to register your project, then it is 1 CR in Gurgaon. That is the amount of penalty. And if there is a delay in completion of project, आपने whatever time you have specified and you have not completed your project, or the construction of the project has not been completed till so and so period, then the penalty shall be 25 lakhs. It will be imposed on developer. These are certain provisions under RERA Act. And in case of non-compliance with regulatory requirements, there are certain regulatory requirements under RERA Act. In case of then, even your RERA registration might get cancelled. That is the thing. Builders should take care of it, and they should maintain better transparency in the system, better functioning of the system, and I think that's the way forward. As a way forward, I would say that first of all, there should be educate digital infrastructure, because most of the things are happening online registration of project, online complaint. So there is online complaint mechanism. I think most of the states, they should have robust digital infrastructure first of all for better implementation of RERA Act. Then we have a good number of court staff so that they can work across different courts, RERA courts, in RERA appellate courts. There should be a better transparency. More stringent provisions should be there according to me under RERA Act, so that there is timely delivery of projects, which is one of the biggest challenge nowadays, that there is no timely delivery of project despite enactment of RERA. And apart from that, they should do something about execution. As we have discussed in the beginning of the session, that orders pass ho jate hain RERA se, but allottees or the consumers, they are facing problem in getting it executed. So still we haven't got rid of this problem. I think governments, they should come forward. And has the session been recorded properly?
It's all good. By the way, thanks a lot for you for such insightful keynote speech. I'm sure the audience who will hear all the things, they will be getting a lot of value, and they will be aware about what to do and how to solve whenever such things will happen in their future, if it will happen.
Right.
But can I ask a few questions, because I have few questions related to this. Okay. So what is the one of the biggest myth about RERA that both buyers and developer are still believing in general in the market, and how does it end up in shaping the market in wrong way?
Pardon? What did you say?
My question was, what is the one biggest myth that both buyers and developers still believe about RERA, and how does it ends up shaping the market in wrong way?
No, it is not shaping the market in wrong way. Market is going in the right way. It's just that we have different states. The problem is not with the RERA Act. RERA Act is a central act. The problem is with the state variation, state level variation. There is, I call it one nation, one RERA plan. It is still not happening. And the second part of your question is that why people still believe, both the builders and buyers, they still believe in RERA. They still believe in RERA because it has brought a lot of transparency. As I have repeatedly said during my session, RERA has brought a lot of transparency. As I told you that now the carpet area has been defined. Earlier there was no definition of carpet area. So what they used to do, builder used to manipulate the price. Now they cannot manipulate the price per square feet and everything, because now it has to be as per the carpet area. And now carpet area has been defined. So anyway, you cannot go beyond that.
Got it.
So the problem is with respect to implementation. Like in Karnataka, in Kerala, we have different system. Here in North India, we have different system. Here, the disposal of cases is, it is happening in time-bound manner, whereas in other states it is not happening in time-bound manner. Few of the RERA authorities are very aggressive in dealing with the cases. Few of the RERA authorities, they are very sluggish in their approach. This is the problem, basically.
On the flip side, if someone is like buying their house for the first time under RERA, what is the like bold one piece advice you would like give them?
Buying under RERA or buying under a RERA registered project?
Yeah, correct.
RERA registered project. See, if first of all, if the project is RERA registered, then the first thing is that it is a fully compliant company, because RERA registration is not an easy task. It is an uphill task. There is a lot of documentation required. You have to submit certain set of documents and approvals with RERA authority. Only after that your project is registered. First of all, my piece of advice is to all the buyers across the country that first of all, always invest in the RERA registered project. If the project is not registered, then I think you should not invest in that project. And secondly, you should definitely inspect the site of the property. Where is the location of the property? According to me, is very important factor. It's just not that the builder name is very big and the project is RERA registered, but there are multiple problems with respect to the location of that property. My advice is go and physically inspect the site area, the location, the convenience, and the development of that area. Only after that inspection, you can go ahead with the property.
Got it, Radhika. Since you have mentioned multiple times during your keynote and recently also that in many cases the LRTs still like felt stuck even with like RERA project like protection, they did not like get those property on time. My question to you is, can you share the most controversial or some interesting RERA cases you have came across in your career that really highlights the challenges on the real ground?
With respect to what, compliance of orders or what?
Like in general, what people face, even though it is like RERA property, RERA registered like project, but still they face on the real ground what major people can see that as kind of a red flag, and they can be aware and they can save themselves from making any mistakes.
See, red flag is you should not fall prey to the brand name of that builder. As I said earlier also, you should physically inspect the project, and if let's say you have invested the funds in that particular project, and the project, as per your builder buyer agreement, whenever both the parties, builder and allottee, they enter into any sort of transaction, buying purchase transaction, then builder buyer agreement is executed. You just properly read the terms. My piece of advice is properly read out all the terms of your builder buyer agreement. That is very important document in these kind of property deals. Builder buyer agreement, there are different terms, but usually we call it builder buyer agreement only. Or read out the terms of your builder buyer agreement properly. Read out the terms of allotment letter. There is one allotment letter also which has been issued. First is allotment letter, then they execute the agreement. Properly read out the terms of your allotment letter, builder buyer agreement. If you see that there is anything which is not favorable to you, any of the clause, any of the provision with respect to that agreement, it is not favorable to you, that is a red flag. You can negotiate with the builder on that particular clause कि भाई ये clause जो है मेरे लिए favorable नहीं है, and you can get it removed always. Before investing a lot of money to that project, then the project is halted for a certain period. Why to get into that kind of a situation? Then you will be miserable. You have invested a lot of money into that project, and now the project is at halt. Your money is also blocked. You haven't got the property also, and now you have to ultimately go for a litigation. So there is a lot of mental trauma. You getting me? Yeah. So it's better that you read. It's always better to read out all the terms of builder buyer agreement properly.
Got it, Radhika.
And if you think that any provision is not in your favor, you can get it removed from the agreement. And despite that, if somehow the agreement has been executed, if the builder has failed to deliver the project within the prescribed time limit, let's say in builder buyer agreement they have mentioned from that the possession shall be given within 5 years from the date of commencement of construction. The construction is being commenced. Let's say a construction is getting commenced in 2018. You should definitely get the delivery of project by 2023. If this is not happening, if this thing is not happening, then you should definitely go ahead with the litigation. You should file case in RERA. You have two scenarios in that case. Either you want to continue with the project. If you want to continue with the project, you should file for DPC, delayed possession charges. एंड इफ यू डोंट वांट टू कंटिन्यू विद द प्रोजेक्ट, आपका एकदम मन उठ गया है कि अब मुझे इस प्रोजेक्ट में नहीं रहना है, देन यू शुड फाइल फॉर रिफंड. देयर आर बोथ द सिनेरियोज अंडर रेरा एक्ट. आप रिफंड भी क्लेम कर सकते हैं, आप डिलेड पोजीशन चार्जेस भी क्लेम. That is totally your decision. What do you want? If you want to stick in the project but you want to teach them a lesson कि भाई project delay कर दिया, तो ask for delay possession charges. And if you don't want to be a part of this project anymore, you are frustrated, then you should ask for refund.
Got it, Radhika. Since like you mentioned that in many cases, even though the project is RERA certified, but still most of the developer, they delay. So related to that only, like I have like a follow-up question on this topic. Is there any pricing loophole in RERA that hardly like no one's like talk about, or maybe the developer are like, taking advantage of if they know? And specifically, has like RERA genuinely protected the home buyer, or has it just like end up becoming more of a shield for developer, or maybe even just another layer in the bureaucracy system of our country?
No, no, no. It's not another layer of bureaucracy. People I have seen a lot is getting benefit from this act. Now there is better adjudication, better disposal of cases. Compliance of orders is a challenge, as we have discussed during our session. Compliance of orders is a challenge, but yes, disposal is happening in a time-bound manner. There is better adjudication of cases, and apart from that, I mean, what was your exact concern?
My question was, is it more advantage for developer, or is there any like loophole that they are like misusing, that maybe like most of the home buyers are like not knowing, or what? I just like wanted to know on that angle. Yeah.
Loophole, no, there is no loophole, but at times, Kedar, there is I would say, shortage of funds on the part of developers.
Okay.
There is a shortage of funds, and 70% of the, as per the provision of RERA, they have to keep 70% of the amount in escrow, project amount, whatever they have received from the buyers, they have to keep it in a separate escrow account. There are certain bottlenecks. They have to maintain a separate escrow account. At times there is a shortage of funds, and as we have seen in one of the case, there were certain unwanted situations in the country itself, which greatly hampered the speed of the construction of the projects, many projects. As we all have seen during the last couple of years, we had to go through. We have seen demonetization. We have seen COVID. And as you have seen this year also, we have seen so many calamities.
All right, like that brings us like to the like end of like today's session.
Okay.
But like really like thanks Radhika for sharing such like valuable insight.